Yeah, okay. At the last hearing, Advocate MNISI addressed the court on the basis that his client is being unlawfully detained, in the sense that he spends only 1 hour out of the 24 hours where he could say that is his own time in prison, where he's allowed, supposed to have exercises, etc. Mr. MNISI also complained about the fact that he sometimes cannot have the opportunity to consult with his client. So the last hearing I undertook to speak to Judge Cameron. I didn't do it because when I told the JP Mlambo that I intended approaching him in connection with your client's complaints, he told me that Cameron, judge, had already written a letter to him. In that letter, they were discussing, amongst other things, the fact that judges of the higher courts, when they make orders which proclaim accused persons who are who are detained, pending them being certified to be compos mentis, meaning that they can stand trial. But before they do that, a psychologist, psychiatrist, or doctor must examine that type of person. And normally the judges only make a blanket order that the accused person is referred to Sterkfontein, whichever hospital, mental hospital or vet copies, whatever. And sometimes in the system, the accused persons are never again visited upon by the psychiatrist. So Judge Cameron was complaining that these persons fall through the cracks because their detention is not defined. And he was insisting that maybe judges should make orders defining exactly that this 90-day period, what should happen to it. And preferably an order which is justifiable to detain this person for mental examination should be about 90 days, but within 90 days or at the end of 90 days, that person should again be seen in court by a judge who will then determine whether in fact this person is being treated or not. Judge Cameron also made mention, it's public knowledge, that he believes that some of the detentions are, as he puts it, are inhuman in the sense that they do not have consideration of the constitutional rights of some of the prisoners, and that sometimes the Bill of Rights has been compromised in that fashion, in that they are not given enough time to go and exercise, they are not accorded time to be visited by their loved ones or relatives or wives, and that he thought that exigency should be visited upon by the Department of Correctional Services, which apparently he did. And JP Mlambo, when I discussed that there is this complaint about the human rights pertaining actually to the detention or the confinement of awaiting trial prisoners, or there are certain complaints which have been visited upon, for instance, by Mr. MNISI. The JP's view, which I agree with, is that this is a comprehensive question of the alleged infringement of the Bill of Rights, and he cannot alone, because there are 5 or 6 or 9 divisions of the Supreme Court, of the High Court here, it must be a general dispensation which is accorded by the Director of Public Prosecutions. So, concerning Mr. MNISI's client, I did a bit of research and I came across this case. The Minister of Justice, Correctional Services and others versus Nduli and Judicial Inspectorate for Correctional Services as amicus. I'll give you a copy of this. This case was finalized on the 13th of September 2023 by my brother Anta Halter. He was sitting with four other judges. And this case, I think it's the most comprehensive decision in South Africa concerning the Bill of Rights as it pertains or affects so-called prisoners or persons who are detained. If you read this case, you'll be able to find your way how you must approach the question of your client. Okay. It pertains only to that one. It pertains only to a so-called accused person or prisoner who wanted to exercise his rights to study, and he wanted to be accorded the right to have a computer which he must utilize for his studies. But it traverses the Bill of Rights pertinently as it pertains to persons like your client. The only way you can visit that exigency is to bring an application to court, as suggested by Mr. Baloi, which will have to define your client's rights pertaining to his incarceration, confinement, study, or exercise, visitations by friends, accused persons, or parents, etc., etc. So your only option, because when I read that decision, apparently it accords with what Mr. Ngumalo was telling Baloi and yourself about the fact that apparently your client is alleged to be, I don't know, a security risk, whatever they mean by that. So you have to bring an application. There is no other way you can do it, because the Director of Correctional Services is the one who frames these regulations which control the incarceration of persons or prisoners, either awaiting or trial or those who are already sentenced. Okay. That's all I can tell you.
As it pleases the court, madam, I'm indebted to the court, and thank you very much.
Okay, thanks.
I'm not so sure whether I need to get a directive from Mr. MNISI.
Yeah, you'll tell him what the law says and what that judgment pertinently says. That's the only judgment in South Africa.
Yes.
Concerning a Bill of Rights, concerning what your client complains about, amongst other things. Okay.
Yes, ma'am. I'm not certain whether I can also request that what the court has just alluded to be interpreted to him as well.
Okay, fine. Mr. Interpreter, are you listening?
Yes, Nonanza.
Yeah, fine.
It was a bit long.
Yeah, okay. No, the salient parts of it.
As the court pleases. Kuthala na Baba MNISI kukhona wa complainer la inkantolo ekhuluma ngeclient yakhe ukuthi ivalebe la ku solitary confinement. Manje ke khona ke izinto eziningi ezabhekwa ukuthi umuntu mevalelwa for 90 days solitary confinement. Kukhona ke imithetho eshoyo ukuthi ufanele abone yijaji ukuze libonakale ukuthi khona yini i-treatment esafanele iqhubeke. And khona ke nje okukhona ukuthi kuthiwa la abantu abavalelwe ke imalungelo awo ababi nendaba nawo ababatholi abantu ababavakashelayo mhlawumbe iy'hlobo nabangani. Ke Tema beyokhuluma no-JP Ndambo kwaba u-Judge President bathe kuthola ukuthi no lokhu akuyona into encane nje yinto enkulu impela ethinta namalungelo abantu and nento ke ngeke akwazi ukuyenza eyedwa kufanele ukhulume nalaba ke abahola ke ezamajele manje kuthiwe ke into ke abafanele bayenziwe ummeli wakho ukuthi kufanele afake isicelo sokuthi kubhekwe ukuthi amalungelo aphethwe kanjani ngathi ngithe ukufika ngaleyo ndlela.
Okay, thanks.
Thank you, my Lord.
Yes,
please. So, my Lord, before I proceed, this morning I was approached by accused number one, my client. Actually, before he made a concern that his identity document has not been given back to him. Then that has been explained, and my Lord, his concern was that since 2020 he requested his identity document.
This identity document?
Correct, man. His smart card. Now the children are going to university and they want to apply for NSPAS. So there is a need, a requirement for the document to be attached
Okay,
to
thanks.
those applications.
Have you asked or visited, canvassed that issue with Mr.
I
Aloy?
have, but
What's his view?
number of times.
Oh. Where's the ID?
Indeed, my Lord, we confirmed that we had discussions and we explained to my colleague Mr. Zulu that in section 31, I think, of the Criminal Procedure Act, this ID document forms part of the exhibit, and up until the finalization of the case, it remains in the custody of the police unless the court orders otherwise. We explained to him that he should make a written request as indicated by the investigating officer, and that is where the matter is, my Lord. Once a written request is submitted by Mr. Zulu, the investigating team will then take it from there. And we explained to him that he must set out the reasons why the exhibit should be released at this point in time.
May I approach accused number?
Yes, yes.
May I swear?
Okay, yeah. Okay, thanks.
My Lord, my instructions further is that this is an exceptional case where the application has already been made to various universities, so they require the document.
They require?
They require that identity document.
Oh, I see, yeah.
And further, he told me that when he was arrested, upon taking that identity document, he was not arrested for this case. He was arrested for the matter that has been finalized in Tembisa.
Mr. Baloi, you say,
Well, the evidence is on record as to what happened on the 30th of May.
yeah.
2020 when accused number one was arrested. It was for the Tembisa case, but that was after the investigating team did an analysis and profiling of the accused regarding the current case. So it is part and parcel of the exhibit in the current matter.
Are you not able to make a copy of that identity document and then certify it?
Yes, I explained to my colleague that we don't foresee that there will be a problem, but obviously a certain procedure has to be followed. There must be record kept of
Yeah,
any
fine.
exhibits that is disposed of.
Yeah.
And I'm sure if you were to follow that procedure, I don't think there'll be any problem. I think the matter has been raised prematurely, and we say this with the greatest of respect with the court. If we don't reach an agreement, can this matter then be brought to the attention of the court? But I'm sure we'll be able to find each other.
Okay, yeah, please.
May I approach?
Yes, yes, yes.
Is it please the court? My lord, unfortunately, Mr. Ngube instructs me that it has come to a point where he can no longer take it because he has been in that situation that I explained before the recess for 4 years.
Yeah, quite.
And now that it is indicated to him that unfortunately there is nothing that can be done in the meantime to assist him, and the only way through which he can be assisted is for him to bring a substantive application before another court to challenge his situation.
Yes.
He therefore requests, my lord, that this trial should then stop.
Stop.
Yes, it is his request. Those are my instructions. That is what he's instructing me.
I know there's a political party which wanted to stop.
Maybe the word stop. It's another way, but then that the continuation with this trial be suspended in the circumstances, my lord, to afford him the opportunity to contact his family, which does not know how he's going to do it, to try and find out on his behalf if there's an attorney and an advocate who will be willing to bring that application for him. Because he is saying, further, he will not be in a position to start to drive or to prosecute that application when he's also concentrating in this case. And most unfortunately as well, my lord, I am also not in a position to assist in that application when I'm also supposed to be concentrating on this case. I can't be expected in the afternoon to go and assist in the drafting of papers, also prepare for the following day to come cross-examine and listen to, to analyze testimonies of witnesses and cross-examine them in this case. It's that will further perpetuate the injustices that he is complaining about, because then I will have to share my concentration. Fortunately, I would not be able to confront two fronts from different angles, my lord. To confront two fronts at a go. That I will not be able to do.
So you're saying this trial must be terminated because you don't want to, you have used the word stop.
No,
so you're saying
I
it must be terminated. What are you saying?
No, my lord. As I said, probably the word stop came out in a rather unsavory way. He's basically requesting that he be afforded the opportunity to try and get an attorney and an advocate through his family that is going to assist him. But the unfortunate part is he will not be in a position to do that when he's also attending this court. So that means for him to be able to fight the battle, which is such a mammoth battle that he's supposed to fight, is for this trial to be suspended for a while.
Suspended for how long? Let me tell you, I've never ever heard of a trial which is suspended on those bases.
Let me then explain the following. Probably the court is also for the first time that is meeting a situation where a person is held in solitary confinement for 4 years. Which is the reason why the court has not yet heard of such a situation.
Wait. I just went out of my way. No judge will do what I did.
Yes.
Research the law and come with an SCA decision to you. And I can tell you, this matter, this has been taken on appeal. Are you aware of that? That was really case.
I know Advocate Mishola that did refer to the case.
Yeah, but
this case at some point.
It's been taken on appeal to the Constitutional Court. So the Constitutional Court, I don't know when they are going to handle that matter, because whatever they do, that case is the most relevant. Because
It's the binding authority.
that's it, yeah.
The circumstances, my lord, of this case, as I heard the court trying to elucidate on them, are different in that somebody who is not held in a solitary confinement is requesting for amenities to enable him to study, like laptop and all those other studying gadgets. But here, we are talking of a person who is mentally drained, a person that has been in solitary confinement, who has got no access to television, who has got no access to a radio, who has got access to virtually nothing, no newspaper, no nothing. And he is supposed, or he is expected to formulate a defense in the case of such a magnitude. That is totally unfair. That is totally unfair. So these two cases are totally distinguishable.
Are you saying just to draft a founding affidavit challenging the conditions under which he's been incarcerated, you need this child to stop?
My lord, I am only conveying what he is.
No, you're fine.
Because maybe he personally intends, because even his funding in respect of this case is done by legal aid.
Yeah, you can apply for legal aid again, no problem.
I'm not even so sure whether, my lord, that they will be able to do that, but I will try. I'll try to communicate with them during lunchtime. If circumstances permit, I'll bring the answer after lunchtime.
No, I can tell you now.
Yes.
The interests of justice don't allow that request. I can't. In this case, there are 4 or 5 accused persons before me. There are the complainants, there are the witnesses, even myself. I can't be sitting in this case until I die.
Maybe, my lord,
So,
in those circumstances, because this is a situation sui generis, probably it will be a justification. Now I'm thinking out of the box. It will be a justification to apply for a separation of trial then, to afford him the opportunity to go and attend whatever that he wants to attend. Meanwhile, the trial, so that to prejudice the other accused with the continuation of the
you say you
trial.
want the separation of trial.
Yes.
What happens to the evidence which has been led? I've never heard.
It will still be relevant.
I've never heard of a separation of trial at this late stage. Never.
But does the court really understand, my lord?
I do.
To stay in solitary confinement
I do. That's why.
for 4 years.
That's
What
why-
does it do to the mind of a person?
That's why I became concerned.
Yes.
I engaged the JP. I engaged the Directorate of Inspections, and I even went to the law. And this is not a difficult application, please. It concerns a Bill of Rights. That's all it concerns.
My lord, it is so. It might not be a difficult application to a person who knows the law.
Yeah.
But to a person like him,
You know the law.
who
You know the
probably-
law.
But I've just indicated, my lord, that I'm not prepared even with an inch to concentrate in this trial, at the same time be involved in a separate substantive application, which has got to do with his
so what
housing.
is your
That I'm not
application?
prepared
Okay,
to do.
fine. What
And
is it?
if I'm not prepared to do it, my lord, then he then has got to do it himself. That is where then that notion of to draft an affidavit for in terms of a person who knows the law might not be a tedious thing, but to a person who knows the law, such as him, it's going to be a very tedious
Yeah, he's
thing.
going to instruct a lawyer, obviously. Okay. I'm sorry, I can't accede to any of those requests. Separation of
take
trials,
instructions, my lord.
stop the trial. I can't do that.
Let me take instructions, my
Yeah,
lord.
fine.
But before I do that, I also wish to bring it to the attention of the court, my lord, that it also hinders me, because instructions that are coming from him, at some stage, they don't make sense. You can see that this is a psychologically impaired instruction. They just don't make sense, man. It also hinders me a lot, and I'm expected to bring sense to the court. How do I bring sense to the court in circumstances where I'm getting instructions that are psychologically hindered by virtue of the fact that a person has been in custody in solitary confinement for 4 years? I don't think even at Guatemala prison that is still the position. Thank you. Let me take instructions.
Yeah, okay, fine.
ask
Yeah,
my concern, my lord? My lord, my instruction from accused number 1 is that the state wants to rely on section 31
to what?
to rely to section 31 to keep the document or the exhibit until the finalization of this matter, of which that was not the same position with accused number 2. Accused number 2, when he was arrested, the state took his identity document and it was given back to him. So he finds no reason why the state should keep his identity document, because there will be no prejudice if such document is presented. And there's already evidence that has been led regarding the identity of the accused that cannot be hampered with.
Yeah, Mr. Baloi.
My lord, I thought we've reached an acceptable arrangement that my learned friend will knock off an email to the state and setting out the reasons for the disposal of the exhibit at this point, and that will then consider that and revert to him, and that the court will be approached if we don't reach an agreement. And I'm hopeful, my lord, that we should be able to
Reach an agreement.
reach an agreement on this point.
You know what? I'm even prepared to make an order to say that your client's identity document is in the custody of the South African police. Its SAP 30 number is this and this and this and this and this. Then your client's identity documents number is this and this and this and this. Make an order to that effect.
Yes.
If you want me to.
Yes, but we think we might not even reach that point. But, I'm sure we can find each other on.
Okay, fine. Is that okay, Mr. Ngomizo?
That would be fine for me.
Yes, sir.
As it please the court, my lord. My instructions are that he has been in custody in solitary confinement since 2019. People have come in and went out. People who have reoffended while in prison, they've stepped police and everything. They've stepped other inmates, they went in and went out. Now, apparently he is told that one of the reasons why he should be kept in solitary confinement is because of this case. Now, his question is, some of his colleagues that are also attending, with in this case, that is co-accused, are not in solitary confinement. So why should it be him that is in solitary confinement because of this case, when other accused that are also involved in this case are not in solitary confinement? He still insists that may the court please have passion, mercy, and compassion to allow him an opportunity to go and think of a situation or of an idea on how best could he tackle this situation. Because he says, my lord, he cannot even concentrate here at court. Because each time he comes here, he's got to think about his conditions where he is housed, as to the reason why is this injustice actually being perpetrated. When he leaves here, he hardly has got time to think about what has been happening here at court for that day, because he spends most of his time in solitary confinement thinking about his agonies. He's basically agonizing about his stay there.
Now, fine, I hear that. He must bring an urgent application. He's got the right to do that.
In the meantime, what should then be happening? Because I've got no instructions
meantime, there's nothing-
to cross-examine this witness.
No. In the meantime, there's nothing this court can do, because the Commissioner of Correctional Services has made an order. Am I correct, Mr. Baloi?
Yes, indeed.
Yeah, I mean,
we try to the best of our
Yeah.
ability to mediate, but it's about
that's
separation
it.
of
Yeah. So
powers.
that order must be set aside.
Yes, they exercise powers in terms of the Correctional Services Act.
That's it, yeah.
And, you
It's
know,
nothing this court can
there's
do.
much we can do.
Okay, can we just start with
This is the message, my lord. The court cannot compel me to start, my lord. I'm a creature of instructions. If I don't have instructions to start, I can't start. But this is
So,
what
Mr.
is saying.
Mr.
Yes.
Are you saying if your client says you mustn't start, you're not going to start?
No, but my lord, I
No, I'm
need
just
the
asking.
instructions. I cannot act against his instructions. And this is what he's saying. Ikhotho uma ifuna ukuqhubeka ngenkani yayo, ingaqhubeka. Kodwa mina yazi ukuthi ngihlukumezekile engqondweni. Ngicabanga indlela engihlukumezeke ngayo. Those are
Yeah, fine.
instructions.
I sympathize, and I'm very human about the situation. That's why I'm saying we can bring an urgent application against the correctional services, the minister, the director, and you can even cite the Department of Justice also.
May I then request, my lord, that we have an adjournment. I consult, actually I talk to legal aid and find out if there's something that he can do in respect of this, because basically he is their client. Thank you.
Yes, Mr. Malloy.
It's 7 minutes to 11. Maybe we can then take the short adjournment, the normal short adjournment until about 11:30.
Okay, I'll come back at 11:30.
Family, we're back again. This is the 7th. Today, we're back to court again on the Sons of Mayowa case. And what is really surprising today, MNISI gave a good warning of his client that if he is not removed in the solitary confinement, whereby he has stayed for 4 years, without radio, newspaper, TV, anything, there's nothing that he's able to use in the solitary confinement while he's going under his trial. And he is the only one in the solitary confinement in this case. It brings a lot of question. Who is pulling the strings from behind? What is exactly happening? Is there any deal that he didn't fulfill in this case that they're disciplining him for it? For not taking an offer, maybe there was an offer that was presented in front of him that, okay, take this case on behalf of so and so. Then we'll make a deal at the end. It seems that there is something behind all these things. Because you cannot keep somebody on solitary confinement and the judge cannot give an order that this person is in court and he's fighting for his release on this trial. Why is he put in solitary confinement when other who are in the same case are not in solitary confinement? This is the real infringement of the Bill of Rights. Because how do you keep somebody like this? It boggles my mind, because it's like there are some people who are pulling strings from somewhere that keep that person there. You cannot trust my lawyer say that, oh, we have tried so hard to work on this case and all this, because these are the really people who are trying to cushion other people who should have been in this case, answering questions about how Senzo Mayiwa died. Where are the powers of the judge? Where do they work? Because at this instance, there's so much infringement of accused number 3's rights, and you don't even understand why that is happening. You try to figure out. But even when you look at Baloyi today, you feel this thing is in his shoulders, because he can't even answer simple questions in court. You could see his face that why these people are bringing this kind of thing. You could even see, even when Advocate Mgomezulu brought the ID problem. Why is it accused number 2 has his ID and accused number 1 doesn't have his ID? Why is it not released? Because it's of important, because this guy has got a child who has to go to school. They need that. Now they're infringing the rights of the kid to have access to his father's documents. What kind of society is being built there? And Baloyi is taking this thing light. This issue has been raised since 2020. To date, it has, and the judge is not coming hard on Baloyi. And as this issue has been raised since 2020, and you haven't done anything, but now you say you can do anything. The court should have issued an order, because there's something wrong there. You should have understood that there's something really wrong that needs to be fixed. That's why we complain that the judge is always light on the prosecutor side, but hard on the defense side. Is it because he's being threatened? Or what is really going on in this case? Family, what do you think about this? Drop your comment. Don't forget to like, share, and subscribe. We will win this battle at the end of the day. Bravo, bravo.